Good.
All right, thank you. Thank you. And welcome everybody to our regular general session of the Judicial Council. Glad that you are here. As always, just a reminder, the meeting is being recorded. It is live streamed. It's open to the public, including the media. As designees, we do have Judge Sean LaGrua is in on our meeting, and she'll be sitting in for Judge Brasher, who could not be here today. And we have our good friend, Miss Elizabeth Fight, who's sitting in for Don Jones, President of the State Bar, who could not be here today. So thank you both for your availability. Ms. Clant, will you do the roll call for us, please?
Happy to do it, Chief. Presiding Justice Namias.
I'm here, thank you.
Chief Judge McFadden.
Here.
Vice Chief Rickman.
Here, thank you very much.
Judge Walter Davis.
Here.
President of the Superior Court Council, Judge Brian Amaro.
Here.
Judge Wade Paget. Judge Jeffrey Kite.
I'm here.
Great. Judge Melanie Cross.
I'm here.
Judge Sizemore.
I'm present.
Judge Asha Jackson.
I'm here.
Judge Sean LaGrua for Judge Brasher this morning. I know she's here.
I'm here.
Thank you, Judge. Judge Fletcher Sams.
I'm here.
Judge Ralph Van Pelt.
I'm here.
Chief Judge Sarah Wall.
I'm here.
Chief Judge Jeff Bagley.
I'm here.
Judge Jim Blanchard. President of the Council of State Court Judges, Wes Taylor.
I am here.
Judge Al Wong.
Here.
President of the Council of Juvenile Court Judges, Lisa Jones.
Present, thank you.
Chief Judge Greg Price.
Present.
President of the Probate Court Council, Kelly Wolk.
Present.
Judge Thomas Lakes.
Present.
President of the Magistrate Court Council, Chief Judge TJ Hudson.
I'm here.
Judge Quinn Casper.
Present.
President of the Municipal Court Judges, Chief Judge Willie Weaver.
Present.
Thank you, Judge Weaver. Chief Judge Lori Duff.
Present.
And Elizabeth Fight for the State Bar, Georgia. Welcome.
Good morning, I'm here.
Chief, the roll is complete and it's time for the approval of the minutes.
Love us some minutes. So you do have the minutes from the last two meetings, the 11/23 meeting and the 11/30 meeting. If you have had a chance to review those, I'll entertain the motion that we approve.
So moved.
Heard PJ move. Don't hear who seconded.
Second, Judge Casper.
Thank you, Judge Casper. Anybody opposed? Those minutes will stand approved. Thank you so much. We are privileged to have with us today Mr. David Amati, who visited with us last year, kind of about this time, about the disclosure filing requirements, and we're pleased that he saw fit to join us again to give us an update. And so without further ado, I'll turn it over to Mr. Amati, who is the Executive Director of the Government Transparency and Campaign Fine Commission, otherwise known as the Ethics Commission. Mr. Amati, thank you for being with us today.
Thank you, Chief Justice, and thank you, members of the council, for having me. And I recognize this joke would land better in person, but I have to start by pointing out that I had technical difficulties in my conference room and I still managed to make it here before Chuck Boring. So I just want the record to reflect that. The Chief Justice is correct. I spoke with you all about a year ago and sort of clarified, I guess, what was an incorrect recommendation from my predecessors regarding the affidavit of public office. And I will concede on the front end, as I did last year, that it is extremely redundant and bureaucratic and red tape that's, practically speaking, not something that's necessary for members of the council, particularly those who are non-voting members who are simply members by being elected. It's redundant of the 3.1 filings you have, as well as your financial disclosures. That having been said, the drafting language does require it. And my sympathies, I have to file this myself, so I'm intimately familiar with it. My hope was that we would remedy this during legislative session last year. Unfortunately, COVID hit, and anything that was not COVID or COVID adjacent kind of went out the window. I do expect that this issue will be fixed during legislative session this year, probably before January is over, though that's not a guarantee. So this is hopefully a one-off, one-time inconvenience, but the members of the judiciary, with the exception of, I believe the magistrate judges council, will have to file the affidavit of public officer this year. I want to stress that there is no actual penalty prescribed in law, so there's no financial fine or monetary punishment if someone misses this or just is a little late, but it is something that will need to be filed. As always, I am here for any questions that members of the council or the judiciary have. You can reach out and I'll work with you directly and help with any questions you have. And Chief Justice, if you'll indulge me for one more minute, I do have one more pitch I want to make that's unrelated to the affidavit. We will be rolling live with the new e-filing system for your campaign disclosures in 2021. We'll have a bit of a soft rollout in January, but by the time the members of the judiciary have their campaign filings in June, it will be a transition and it will go live. It is a system that replaces a 20-year-old system, and I know the Chief Justice won't appreciate this, but as a Georgia Bulldog, I had a little bit of flexibility and autonomy, and so the new system will be fully red and black in the colors of the University of Georgia. Go Dogs. But again, with that, any questions you have, reach out to me directly. I know Justice Peterson has already done so, but if there are any members who want to either themselves or with their filers be part of our beta testing group to sort of work out the kinks and bugs in late December and early January, reach out and we'll bring you into that portal as well.
Thank you, Mr. Amati. Any questions for Mr. Amati? All right. Well, we do appreciate that you would deliver the news personally, and we also appreciate your openness that you've exhibited since you've been in office to be available to any questions we might have. We appreciate the back and forth, and it helps us stay clear out of trouble, which is, we know, is your overall objective. So thank you so much for being so accessible.
Thank you, Chief Justice. And again, I hope to legislatively fix this issue, which Justice Namis and I talked about last year, and hopefully this is a one-time thing that we can take care of.
All right, thank you. So let's move on to the Judicial Council committee reports. The first committee report is the Judicial COVID Task Force report. Judge LaGrua, you're here. I know Judge McClellan is here, and I've got a couple of quick updates for you, but do y'all have anything to share?
Just briefly, Chief, thanks. Good morning. One of the things that we're working on, because the experiences with the CDC and COVID have changed over time in terms of definitions and what is appropriate, we're going to be trying to put an asterisk to the reports on the computer that indicate where it says following CDC guidelines and applicable health guidelines, that these documents may have been created early on in the COVID situation, and they need to check the CDC website to make sure that they're using current CDC guidelines. It doesn't make sense to try and go back and change every document every single time the CDC changes a definition or a guideline, but we're going to try and make sure that that's on the website so everybody knows to check the CDC website for any updates on, for instance, vulnerable persons has changed, the age has changed, those kinds of things that were in our original documents may not be completely accurate anymore. The civil subcommittee continues to work on civil remote voir dire and trial. They are suggesting that parties, that judges in particular, ask for consent of the parties to proceed virtually on jury selection and potential trial if and when we get to that point. The technology committee is working on best practices and an easy way to show exhibits, and that will be shared with the criminal subcommittee as well. Additionally, the civil subcommittee has come up with a one-page discovery dispute summary that folks can use, a guideline to present to a judge when they have a dispute that would make it quicker and easier for the judge to get involved and hopefully facilitate moving cases even in COVID. I know Judge McClellan's on. Chief, could I reach out to him and ask him if he has any additional updates on the civil side?
Absolutely.
Judge McClellan? Maybe he didn't make it. I think I got everything because I talked to him this morning before the meeting. So if he comes on, maybe he can jump in.
Yeah, I saw that you earlier.
Russ, you muted.
Can you hear me now?
Yes.
Yes.
Sorry about that. Yes, I think you covered pretty much everything. We're pretty much ready to submit our report to the full task force, the document that we've prepared. So we'll be looking to do that at the next time the full task force meets. But I think Judge LaGrua covered everything that we've been working on, and we have a really good group that's working well to try to come up with best practices for people that will help lawyers and judges going forward.
The criminal subcommittee chief is working on some language to amend the statute on alternate locations to allow for a little bit more flexibility for courts that have a problem having court, juries, whatever within the court complex because of COVID-related issues, be it size, space, COVID outbreaks, those kinds of things. I think there is going to be some encouragement for encouraging acceptance of written waivers of arraignment when appropriate, encouraging discovery in digital format, and allowing remote proceedings, even if not already allowed, if consented to by all the parties. Those are sort of the high 10,000-foot highlights. We've gone over most of the stuff we've been doing for the last 8 months previously, so I won't belabor it at this point. We remain open to any input from anyone that wants to give us on any of these issues. Please email myself or Judge McClellan directly.
Thank you, Judge LaGrua, and thank you, Judge McClellan. The other item that I wanted to update with you is the newest judicial emergency order that was issued on Wednesday. You may have noticed that it differed perhaps significantly from the emphasis that was contained in our previous drafts that we had circulated to you. Literally on the brink of issuing that order, we started getting more numbers and more information about the scope and size of what was happening across the state. And it caused us to really shift pretty quickly in what became the emphasis in that order. And so given the numbers that we see statewide, the tone was redirected towards making sure that you all keep in mind that we might need to call it audible if necessary, as numbers to continue to increase. We've been trying to move forward on jury trials. We've been saying all along that nothing that we were doing to move forward was irreversible, but we might have to back up on jury trials. We might have to back up on grand juries. We might have to back up on other in-person proceedings. And so that became the overarching tone that we wanted to emphasize in the last order. Along with that, again, if we could avoid anything coming into court that doesn't have to come into court, let's do that. Let's utilize our let's utilize our virtual conference technology and capabilities to the fullest extent possible. Let's manage our case calendars so that we are not bringing any more people than necessary into the courtroom at any given time. We need to minimize not only the presence of individuals in the courtrooms, but also in the hallways. And as the weather gets a little colder, we don't have the option of having people maybe wait outside the way they otherwise would have been able to. So all these things are central to getting us through to the finish line. We are optimistic, of course, that a vaccine will relieve a lot of the stress that we're seeing statewide. But we got to finish the drill on our end, and y'all have been doing that. But this is just more of a wake-up call to recognize just where we are at this moment. So that's what I wanted to share about that order. So thank y'all again for everything. I'm grateful for your leadership and your accessibility and what you're doing to keep the spirit of justice throughout the state alive and well during this time. With that, I'll turn to the Legislative Committee and ask our presiding justice, David Namies, to give us a report there.
Thank you, Chief. The written report and the information we'll discuss begin on page 28 of the PDF behind tab number 3. The Standing Committee on Legislation has met twice since our last Judicial Council general meeting on November 17th and December 2nd to discuss proposals for the upcoming legislative session. We may well meet again before or at the beginning of the session to discuss additional proposals, particularly of the sort that Judge LaGrua just mentioned relating to other pandemic-related legislative possibilities. As a reminder, the committee and the Judicial Council vote on items and make recommendations in concept, allowing our legislative team to make adjustments to that to those proposals as the legislative process goes on. There are 2 items for specific discussion today. The first item is for informational purposes. On November 17th, the committee heard an update on the court reporting legislation that Judicial Council has supported in the past year. There is an updated draft of that proposal dated October 15th that was presented to the committee and is included in your materials, that the main part of which is removing the proposal for having a license category for certified digital operators. If we have Chief Judge Rickman from the Court of Appeals, who's the chair of the committee, I can turn it over to him to provide any other background on that development.
Thank you, Justice Namies. There's nothing much to add other than to thank our committee for all the hard work. That particular requirement being removed, the subcommittee and Judge Morrison surveyed the entire country, and it was determined that the additional layer of a license just for the operators of the digital equipment. So to remind you, there would be a licensing category for the folks who actually turn the equipment on and off. The proposal for that to be a licensing category has been removed for multiple reasons. They didn't discover that other jurisdictions actually did that. And second, as you know, in Georgia, with our diverse judiciary, there are very many judges who actually sometimes have to operate the equipment themselves. Different court staff have to play multiple roles. Some have to turn the equipment on. And so that was thought to be not necessary. And that's all I have to add. Thank you.
Thank you, Judge Rickman. So that largely is just for your information of a significant development in that proposal. Are there any questions or comments about this item? All right, then we'll move on to the more significant item, action item on the agenda, which will take a little more time to discuss. On December 2nd, the Legislative Committee met to discuss pandemic-related legislation, and in particular, a proposal to allow the continued tolling of statutory speedy trial requirements following a judicial emergency. Again, this proposal is in your materials. And as a little bit of background, as almost all of you know by now, there is existing legislation that are existing statutes that we were very fortunate to have in place before the pandemic that allow the Chief Justice or the Chief Judge of a Superior Court to issue a judicial emergency order that tolls statutory deadlines and requirements, including statutory speedy trial requirements. But those orders are limited in duration. They're limited to 90 days if they're kind of freestanding orders. And the only way to go beyond that is if the judicial emergency order is issued by the Chief Justice and tied to a emergency order based on public health that's issued by the governor. So the reason we've been able to continue statewide judicial emergency orders is because the governor has continued public health emergency orders. At some point, those governor's orders will end, probably not, in the very short term, but as we emerge from the pandemic. And at that point, under the current statutes, the authority of anyone in Georgia to continue tolling statutory requirements also will end. As we've all experienced, we've been able to make the judicial system function in lots of other proceedings by doing a lot of them remotely, and then by starting up in-person proceedings. Although, as the chief just noted, we may now be in a situation where we need to ratchet back on in-person proceedings. But the one proceeding that is kind of last to start are jury trials, because of the number of people that are involved in any jury trial process, particularly jury selection, but then also jury trials. And that's why they were authorized to restart last of all proceedings. And we've had very few jury trials since March. Many of you were planning to have jury trials. We'll have to see, and as the chief said, think very seriously about whether those plans should continue. But even if we get jury trials going during the pandemic, they're going to be much fewer and far between and slower than they are in normal times. On the other side of the process, the criminal defendants have a right to have their cases resolved by jury trial, and also have a right under the Constitution to a speedy trial. Now, civil litigants also have a constitutional right to a jury trial, but there is no requirement that that happen at any particular time. So as we emerge from the pandemic, the hope is we will be able to get back to civil jury trials. But if we don't, there's no kind of direct penalty. If you violate constitutional speedy trial requirements, the defendant is acquitted and released. But constitutional speedy trial is a flexible balancing test in which you can consider the reason for any delays. We also have statutory speedy trial requirements that have been around for almost all of Georgia's history. And on that side, you do not look at the reason for the delay, and it is not a flexible test. It is a very kind of cut and dried, how much time since the demand was made test. As most of you know, we have very different terms of court around the state. Every county has a different term of court. Many of them are 6 months, but in the largest, most populated counties, they are as short as 2 months. And so statutory speedy trial demands may allow only 4 months or less to get a case tried in some of our larger jurisdictions. And even if it is a life sentence case, you may have only as little as 8 months. And so the problem is we have accumulated already 9 months of jury trials around the state. By the time we finish judicial emergency orders, we may be well over a year of jury trials largely accumulated. And for many of your jurisdictions, we function pretty close to capacity in good times because of the resources available. And so, as we've discussed generally, we need to have some way of getting through this backlog of jury trials, because the remedy for not meeting statutory speedy trial demands is the defendant is discharged and acquitted. There is no trial at any point. The defendant's guilt or innocence is never determined. The victims of the alleged crimes never have any opportunity to have the case tried. And so we have tried to come up with a way to extend speedy trial requirements. There are only two classes of court to which this will apply, superior and state courts that do almost all of the criminal jury trials. And we definitely think it is something that should be done at the local level. As we come out of the pandemic and judicial emergency orders, there may well be a need for tolling almost everywhere in the state, but different courts, state and superior in different counties, are going to face different levels of backlog, different resources for working through the backlogs. And so the proposal has been structured for the authority for these orders to be exercised by the chief superior court judge or the chief state court judge, and at the county by county level. I'm going to turn it over. We should have Darren Enns, who is with the AOC. He's done the yeoman's work in helping pull this proposal together. And let me turn it over to Darren to just walk you through it pretty quickly.
Thank you, Presiding Justice. My name is Darren Enns. I'm Policy Counsel here at Judicial Council AOC. And it's my pleasure to walk you through the version of speedy trial legislation recently considered by the Standing Committee on Legislation. If you look on the first page of the proposal, you can see that we've added an exception to 38.361B on line 26. And this is the section of current law that Presiding Justice Namias was referring to that limits the duration of a judicial emergency. So we're making it clear that this is what we're proposing is outside of those limits. On the next page in section 2 is the bulk of the proposal. Go down to the bottom of the page where we're adding a new subsection B. We're redesignating the existing part, the existing law here in 38.362 as A. So we're adding a B. Subsection B would provide a chief judge of a superior court judicial circuit or a chief judge of a state court the authority to suspend, toll, extend, or otherwise grant relief from statutory speedy trial requirements following a judicial emergency if compliance with such requirements is impracticable. We defined statutory speedy trial requirements because this only applies to those statutory requirements as those included in Code Section 17.7.170 and 17.7.171. And that definition is in paragraph 1. You can see that paragraphs 1 through 12 set out the rules for how the authority in the main clause B is to be administered. In paragraph 2, it says what impracticable means for purposes of this subsection. It's not a bright line definition. It's more of it's a totality of the circumstances test with factors. And the totality of the circumstances arising from the preceding judicial emergency are what are going to be considered, particularly whether you can comply with statutory speedy trial requirements, whether it's impracticable in the applicable county and court, based on the factors laid out there in A through E. You'll notice that in E, there's a catch-all other relevant facts to justify relief in case one of these factors is, if we miss something or if there's some other fact that would justify relief. Some of the factors here include pending criminal case volume, annualized criminal case clearance rates, ongoing space limitations or other health and safety concerns, limited availability of judges, courtroom personnel, prosecutors, public defenders, etc. And moving on to paragraph 3, you'll see that there's a certification that's required to accompany any order that's going to be granting relief under this subsection. And that certification is going to be tied to whether compliance with statutory speedy trial requirements is impracticable. It's going to be based on paragraph 2, the factors there. And each time a chief judge issues this order, they're going to need to also provide the certification. There's a couple ways that the certification can be generated. In 2A, you'll see that there's the option there for the chief judge to personally certify, And in 2B, there's this is a reference to a majority provision, which I'll discuss in just a moment. The certification is going to come from either a majority of Superior Court judges in the Judicial Circuit or the majority of state court judges in the state court. And you'll see that's going to come up in just a moment. In 4, you'll see kind of all of the powers are kind of laid out here of a chief judge in a superior court. It's 4A through D here, may act independently of an emergency declared by the governor. That's the whole premise of this proposal, is to operate independently of a public health emergency declared by the governor. So we included that. The chief judge may grant relief from statutory speedy trial requirements in his or her judicial circuit in the county, in a court for a county in his or her judicial circuit. And then 4D references again this majority provision where the chief judge must act at the request of a majority of superior court judges in his or her judicial circuit. And that is specifically laid out in paragraph 5, where it says that the chief judge shall grant relief if requested by the majority of Superior Court judges in his or her circuit. It lays out that the majority is responsible for providing the certification required in paragraph 3. In paragraph 6 and 7, there's corresponding provisions of what I just mentioned for a chief judge of a state court, applying it to a chief judge of a state court specifically. Particularly may grant relief from statutory speedy trial requirements in his or her state court, because that's going to be their area of authority there. Paragraph 7 is the majority provision as it applies to a state court judge, and state courts, a majority of state court judges are going to, if they ask, the chief judge must provide relief. Paragraph 8 lays out the initial period of relief. We have initial period, the subsequent period as well in 9. The initial period of relief is going to be basically some combination of terms of court limited to 6 months. Likewise, the subsequent terms of relief or subsequent periods of relief in paragraph 9 are also going to be 6 months per order. Moving on in paragraph 10, if a chief judge issues an order granting relief under this subsection, they're also going to need to provide notice as currently required under the judicial emergency code sections. And that particular notice is laid out in code section 38.363, with the exception that the notice is going to need to include the certification that I just discussed. The Chief Justice is on that list of people who are notified in code section 38.363, and accordingly, in paragraph 11, the Chief Justice is going to provide some accountability for the use of such authority. And in particular, a Chief Justice would have the discretion to reinstate statutory speedy trial requirements subject to an order granting a relief under this subsection. If the Chief Justice does that, he or she is going to need to provide the same notice in code section 38.363. And also a Chief Judge will no longer be able to grant relief under this subsection if the Chief Justice takes such action, unless the Chief Justice reauthorizes the Chief Judge to do so. And finally, in paragraph 12, it makes it clear that this is statutory speedy trial requirements only, and that the state still bears the obligation to provide, the constitutional obligation to provide for a speedy and public criminal trial. It would be effective upon its approval by the governor or upon it becoming law without such approval. And in section 4, it's boilerplate language for conflicting laws. And that concludes my summary of the current version of the speedy trial legislation.
Thank you, Darren. I'll
You're
say that this version included input from a number of judges on the councils of Superior Court and State Court. It will likely be refined in some respects. We've had already some very useful input from a number of stakeholders in the criminal justice system, particularly as to potentially listing some additional factors or data that should be considered in adding to the certification, some idea of having a plan from the get-go of how courts are looking to work their way out of the backlog, and also a priority of calling cases. The biggest concern with all of this on the other side, which is a very legitimate concern, is we have a lot of defendants who are being held in custody awaiting trial, and the longer speedy trial demands are told, the longer they may sit in our jails without their guilt or innocence being determined. And so we really do need to prioritize getting those cases moving. And I would encourage all of you to think about other steps to address those cases and try to figure out ways where they could be resolved without jury trials, on how to encourage that. And we're looking at some other legislative proposals potentially in that area. And then the other thing that probably will be added, but we're still working on exactly the structure of it, is some ultimate time limit for how long these orders could last. As Darren said, it's structured to allow them each one to be effectively 6 months. But there probably needs to be some limit. And it may be tied to the length of the judicial emergency. Right now, we don't, we were kind of on a heading thinking we're going back to jury trials, but now we may be on a heading of we may not have many or any jury trials over the next month or 2 or 3. And so it may be flexible based on the length of the emergency. But that is the structure of the basic proposal, and we're asking for a vote in concept. Are there any questions or discussion of the proposal?
Justice Namias, would you elaborate a little bit on the procedure by which the input we've received will be evaluated?
We have shared the proposal as soon as it was circulated to the Legislative Committee with stakeholders such as GACTL and the public defenders, PAC, ACCG, because counties, many of the expenses associated with jury trials are paid for by counties, and they will definitely have a significant stake in financially and otherwise, and then also just generally. And so we've already received input that'll be considered first by myself and AOC, and then probably shared with Legislative Committee for input as we go forward. And as we get to another kind of solid draft, that'll be shared at least with Legislative Committee, which is how Judicial Council operates between its general meetings. Any other questions at this point? Okay, then Chief, I have a motion from the committee. Standing Committee on Legislation recommends that the Judicial Council support legislation to amend OCGA 38-361 and 38-362 to provide for tolling of statutory speedy trial requirements following a judicial emergency.
All right, thank you. We have a motion. Is there a second?
Second, Judge Casper.
Thank you, Judge. Any discussion? Let me point out by way of process, when we did our workload assessment votes, we had a formal login and screening process where we voted electronically. I think that was a heightened process for a heightened cause. For our standard votes, I will ask simply if anybody opposes, so we don't try to hear everybody at the same time, if that's agreeable. If we need to do something more to dig in and go layer deeper, we can. So with that and said, we have a motion, we have a second, we don't have any further discussion. Is there anybody who's opposed to this proposal? All right, well, thank you. That will stand approved in concept, and we look forward to updates. And there has really been a lot of work on this. And Darren Enns in particular has done a good job of hearing from a lot of people and capturing those thoughts and concepts on paper, and that process will continue. So thank you, Darren, in particular.
Just a couple final remarks, Chief. We appreciate everybody working together on this legislative proposals and others. As always, we urge all of the councils and other players in the Judicial Council process to keep each other updated on items that your council are working on. And if it affects other councils, to make sure it does go into the formal process of consideration. And we are going to start regular Friday Zoom meetings for updates on the legislative process as the session begins in January. But again, thank you to everybody for your participation in the process. And that's it for me, Chief.
All right, thank you. Thank you very much. And yes, please do remember, just to keep everybody informed, open communication on legislation. For the Judicial Workload Assessment Committee, we have Judge Emerson. Judge, are you there?
Yes, thank you, Chief Justice. Good morning.
Good morning.
And good morning, everyone. I'm going to move as quickly as I can. We have a specific recommendation that is an action item that will require a vote, and that is something we've addressed. Mr. Christopher Hancher did a lot of work on this in order to go back to our previous time and motion study and pull out the data from the habeas corpus cases and work along with the National Center for State Courts to develop a new case weight for what I call prison habeas cases. The previous time estimate in our system for counting workload uses a system of average minutes for certain case types. And we previously used a case weight. If you look at tab, I believe it's tab 4, page 3, you'll see the previous case weights, and we gave 44 minutes to habeas cases. The judges in the circuits that have prisons came to the committee and indicated that those cases require significantly more time. And so we do have a new recommendation based upon empirical data. And that case weight, if you look at page 2 of the report, is 136 minutes for habeas corpus cases. And we'll have a weight of 42 minutes for what are called civil appeals. And that will, in order to approve that, it does require vote of the Judicial Council to make that part of our policy. Does anyone have any questions for me in regard to that recommendation?
Judge Emerson, by way of background, do you recall what the previous weights were?
The previous weight was 44 minutes. That's on page 3 of your, the weights, the table, there's a table in your materials that lists all of the previous weights. And if you look down there, civil appeals, habeas corpus was 44 minutes for those cases. This is a significant increase in those cases. This is more than what we give for routine felonies.
Okay. Any other questions?
Chief Judge, would you please define civil appeals?
That would be workers' comp, appeals from what we get these days are magistrate appeals and dispossessories. Get a lot of those, but any type of appeals from the limited jurisdiction courts, civil cases.
Okay, Judge, you have a motion to approve. Is there a motion to approve the adjusted weights for new habeas and civil appeals case weights?
So moved.
Thank you, Judge. Is there a second?
I'll second.
Judge Sizemore. Any discussion on this motion? Is there anybody who opposes? That will stand approved. Thank you. Thank you, Judge. I think you have more.
Yes, Chief Justice. And you have the detailed report there from Mr. Hancher on the work involved in that, the development of those numbers. This is not something we make up. And we also hope to get funding for a new time and motion study that this council has supported the recommendation to include that funding in the budget for next year. All right. In terms of update on policy on the study of Superior Court judgeships, you have a report there that relates to what are called the overjudged circuits. And this is where we have circuits that appear to have more judges than they need. Their workload is less than 0.9, their judicial workload. And of course, the policy is that 2 judge circuits, we don't go below 2 judges in a circuit. That's Judicial Council policy. It's been the policy for a very long time. And basically, we're trying to just eliminate we have a couple of 2 judge circuits where their workload is below that. But for example, the Patala circuit, I think was one of them. Well, they have 7 counties. I don't know how 2 judges ever cover 7 counties, but as a Superior Court judge myself, blessed to only have 1 county. So that's basically just a policy change. So I do ask for a vote to approve this policy change in our study. This would go into our manual. All of this is done in Judicial Council policy in terms of how the committee does its work and what kind of information we publish once the workload report is done. And the recommendation is on page 6 of the tab that you have from the committee.
All right, is there a motion to approve? Judge Emerson calls that a policy change. I'll tell you that it was my understanding, maybe that was a cultural understanding that wasn't embedded in anything in writing, but that was my understanding all the while. Is there a motion to approve this recommendation?
Move we approve.
Okay, I thought I saw PJ first. Judge Seisler, I'll give you a second. All right, is there anybody opposed? That will stand approved.
Our third item is,
go ahead.
Thank you, Chief. Our third item relates to 2020. And the committee, after discussion, voted that we would not make judgeship recommendations, basically suspend the study, because we all know that specifically, we have not had indictments for many months. So our case numbers are down significantly. And that's not a fair number to use in evaluating workload of our circuits. So we recommended that we suspend the annual judgeship study and the process for new judgeships for next year. In other words, we won't use 2020 numbers. The workload would still be published, but with reminders about the pandemic's impact. This is all contained on page 7 of your materials under that tab 4. And all of the circuits that already have recommendations for judgeships would receive an additional year of eligibility, and we would suspend the review requirement that relates to if your workload dropped below 10%, you would lose your recommendation. That is suspended. We have had a question about this recommendation from the General Assembly, and it was specifically asked to me yesterday by Superior Court judges, and that is, what about circuit boundary studies? And we normally will do a circuit boundary study, are required to do a circuit boundary study if any legislator or various interested parties request that we do that. And so in order to get an answer to clarify whether we would do, and there is a circuit that is specifically interested in a boundary study this year. So I had Christopher reach out to the members of the committee for their clarification and vote on whether or not this recommendation to suspend the judgeship study also suspended boundary studies, because we didn't specifically enumerate that. And the answer from the committee was, from all those who voted, was that yes, we would not undertake boundary studies either. So that is the recommendation of the committee, that we would suspend judgeship studies and boundary studies. I'm going to just clarify that for next year based on the COVID crisis and the impact on the numbers. Any questions?
So, Judge, if we do have some requests already in for new judgeships, and you mentioned the boundary split requests. We don't have good data for 2020. We do have data for 2019. Most of that data has already been massaged in to the extent possible. Is that correct?
Yes, we do have 2019 numbers.
Okay.
Can I ask, just to be clear on the boundary study, the existing policy has a deadline for requests for boundary studies, I think in June of the year, and we did not receive any boundary study requests by that deadline for this calendar year, right?
We addressed, I'm trying to remember, I do remember we had one out of Coweta, but
okay.
You know, that was eventually sort of withdrawn. It was, I think the DA down there was asking for a study. And by the time when we did the study, it was really, it was clear it was not going anywhere. We addressed that, I believe, last summer. This year, I'm pretty sure there is a desire for a boundary study in Augusta. That's the only one I'm aware of right now, but I don't know. And Mr. Hancher's on the conference. I don't know if we've received a formal request for that yet.
We have not.
Okay. And of course, we'll provide whatever information we have and be as responsive as we can, but we do have limitations just on the sheer fact that we don't have real data at all for 2020.
And I point out, you know, this is merely when the Judicial Council, the committee makes the recommendation of the Judicial Council and the Judicial Council votes. These are recommendations. If there's a legislator or, for example, a Speaker of the House or whoever who has real power, who just wants a new circuit, they can always drop a bill. We don't control them. These are only our recommendations.
All right. So can you phrase that motion for us?
We recommend that future workload analysis would exclude our 2020 data, and we would suspend the judgeship recommendation process for 2021, including circuit boundary studies.
Okay. So that's the motion. Is there a second?
Second.
We heard second. I got Judge Weaver. Any further discussion? Anybody opposed? That will stand approved. Thank you, Judge Emerson, and thank you and Christopher, especially on the weighted case study. I know that was a lot of work. We had some circuits across the state that were really craving that work, and I know they're pleased to see the new numbers there. And thank you for your diligence and making sure we got that done. Don't take that lightly. Judge Emerson, we'll stay with you on the Technology Committee.
Thank you, Chief Justice. Before I move on past that, I want to say we're losing Christopher Hancher. He's one of our courts has had the temerity to hire him away from us. And I've worked with a lot of folks over the years, and Mr. Hancher has genuinely improved the justice system and the system for counting our cases during the years that he has worked with me on this committee. I'm going to miss him. I know that he's going to do a great job in Cobb County, but I do want to express my personal appreciation to Christopher. He's the guy that I can always come to whenever I need information. And you know, this is tedious work, you know, a little bit. Not many people are real interested in these numbers. Christopher is passionate about them, as I am. And so we've been very fortunate to have him working with us. So thank you very much, Christopher. Moving on to technology, because I know that we're running behind. Get over to that report. You all do have a report in your materials. We are working on some projects beyond the report itself. I'm working on trying to improve the reporting by the courts of criminal case dispositions. That's what we call TERs. And so you're going to hear a lot about that from me over the next year or so. Time expired records is what those are. And right now, Georgia's numbers are not good on reporting criminal case dispositions. I've studied that, and I have reached out to Pete Skandalakis, who is the head of the Prosecuting Attorneys Council. And what I plan to do is develop a criminal case filing information sheet, similar to what we do in civil cases. And this would be something the prosecuting attorneys would file. It would contain what I have found in my own circuit when I studied cases that weren't reported. They were frequently missing what's called the OTN. And that's a critical number that's generated by GBI when a defendant is fingerprinted, and it is related to the transaction itself. And so I'm trying to improve the reporting and the ability of trial courts to get that number, get it entered in our databases so that our dispositions will be reported and reportable, because you can't report a disposition to GCIC without an OTN. So I'm working on a draft of that form. You all will see it. I'm going to try to keep it simple. The main thing is for us to be sure we have the OTN. And that report will also address another problem, and that is getting the prosecutors to tell the clerk when a charge in a case is a serious felony. And if you look back at the previous tab, you'll see that we count serious felonies significantly more than routine felonies. And right now we count on non-criminal justice system educated data entry clerks in clerks' offices all over the state to figure out if a case is a serious felony or not. Well, I want the prosecutors to tell us that. And Mr. Skandalakis understood all of these issues when I talked to him. And so he's very enthusiastic about this idea. And so I'll eventually come to you all with some recommendations on a specific form for criminal cases, which we've never had before. The other thing that we're working on, Judge Altman is helping me with this, and that is solving how to address the failure of the courts to report GCIC no contact orders entered in criminal cases. The legislature amended the statute on family violence protection orders to say that no contact bond orders and no contact sentence orders are supposed to be reported to the family violence registry. And they're actually supposed to be reported within 24 hours of the time they're entered. And currently what the clerks of Superior Court, and only the clerks of Superior Court do, they use a system developed by the Clerks Cooperative Authority in 2002, using 2002 software that Judge Altman helped me find that out, to report family violence protection orders to GCIC. Well, this change actually applied to all of the courts, everybody from juvenile court, magistrate court, every court that enters any type of order that includes no contact language is supposed to report this to GCIC. And, the Superior Court judges, actually, we changed our Rules Committee changed our forms and set them up to comply, but there's no software or there's no interface for anybody to report it. So Ben Luke, our new AOC technology director, came out the other day and looked at the system. And so Ben is working on developing some type of estimate for what it'll cost. So I'm working with Ben on that because, this is something it will require an interface that will serve all of the courts that issue no contact bond orders. I have no idea what something like that will cost. We can't ask the Clerks Cooperative Authority to do that because they only serve Superior Courts anyway. And, they're not aimed at other courts. So Ben and I are working on that. I hope to have more recommendations, more information on that in the future for you. Mr. Chief Justice, that's my report. Any questions?
Thank you, Judge Emerson, and thank you for your hard work. We really appreciate it. Let's move forward to the Cybersecurity Insurance Implementation Committee. I think we have Justice Bethel here, at least I know he's observing and watching. We have a written report. I don't think he has any remarks. So if that remains true, we'll move on to the Strategic Plan Committee. Likewise, Judge Doyle has submitted a written report. I don't think she has anything to report verbally. I know Jessica Farah is available if you have questions about that. So if that remains true, we'll move through. Does anybody have questions there? All right, then we also have then on item G, the Unified Administrative Services Committee. On this, you have a written report, and Stephanie Hines is available. Here, I do think a little bit of conversation would be helpful. Ms. Hines, can you give us an update? And I'll be happy to the extent that you feel like I'm catching you cold. Are you there?
I am, Chief. The committee has met twice since the order, and there are some in-person meetings that have been held. And Justice Ellington is still currently working, and the committee continues to work, and we hope to have an update regarding any extensions in the months to come. So that's where we are right now.
Okay.
And the written report pretty much captures, everything that's going on.
So just by way of background, you may recall that in the last budget tracking sheet that was passed by the legislature, it had language in it that directed various court entities related to the Superior Court, the Business Court, the Court of Appeals, the Supreme Court, I believe State Court, Juvenile Court. I might be missing a couple, but there are several. And we were all urged to figure out how to unify certain back office operations from payroll to IT and cybersecurity. And we had a reporting deadline, I believe, of December 1. Justice Ellington has chaired this committee, and what he has done is basically talk to House and Senate leadership first and communicated to them that we took their direction seriously and have taken their direction seriously, but we've also, as a judiciary, have been preoccupied with all the adjustments necessary to reconfigure operations to line up with COVID requirements. And if we're going to do this right, it's going to take more time and more thoughtfulness. And so he has sent a letter explaining that to them, but that letter really just follows up on the conversations that he already had. So we expect a reprieve on that. For how long, we don't know, but for now, the urgency has been abated somewhat by his work and conversations, and also the work of that committee. So that's where we stand for now on that. So that concludes the report on the Unified Administrative Services Committee. And let's take a break. It's now 11:05. We've gone for an hour. It says 5 minutes. Let's give it 10. Let's come back at 11:15. Cynthia, I can't tell if you can tell to what extent people are back.
If we've got most of our members back,
All right.
so
Well,
if you'd like me to get started, I am happy to move forward with the AOC report.
Let's do that, Ms. Clanton. It's on you.
Okay. The AOC continues to stay calm as we carry on during this global pandemic. Although we do eat chocolate from time to time, at least I do. We remain vigilant in our safety practices and hope that 2021 will see an end to the need for social distancing. Whether virtually or in person, we look forward to serving Georgia judges for the rest of 2020 and a long time into the future. 2020 has been quite a year for the Judicial Council. We've had 27 Judicial Council meetings since March. Normally, we would have had 2 during that time frame. All of our Judicial Council committees have met since our last Judicial Council General Session in August, and the work of those who staff those committees presses on. Thank you all for staying engaged. We have our annual report completed for this year, and we'll send that to you electronically. Please take a look at that document and let us know if you see anything amiss. The annual report goes to the printer in 1 week and will be mailed to you and distributed to all the Georgia legislators. Since May 2020, the Judicial COVID Task Force has been working at a fast pace to create guidelines for restarting grand juries and jury trials. The AOC is the repository for all the pandemic-related local emergency orders, court operating guidelines, and jury plans. Once submitted, the AOC posts those documents on our georgiacourts.gov website. We're grateful to Judge Ken Hodges, who was instrumental in securing funds to create and distribute the Justice Needs Jurors PSA. The Chief Justice played a starring role in the first PSA, but we've also distributed funds at a local level to create PSAs for individual circuits. All of this work can be accessed at georgiacourts.gov. The PSA featuring Chief Justice Melton will likely be distributed widely on media platforms after the holidays. And we are grateful to the State Bar and the Commission on Professionalism for assisting with the costs of this unique public outreach. In court news, we deeply mourn the loss of our friend Justice George Carley on Thanksgiving Day due to COVID-19. Justice Carley was a bulldog, a true gentleman, and a mentor to me. He will be missed deeply. Also this week, we grieved the loss of a municipal court judge, Bernita Lee Bender from Valdosta, who assisted the AOC with recent outreach efforts. She has left us too soon, and our thoughts are with her family. On a happier note, Superior Court Chief Judge Brian Amaro, shown here in the mask, looking quite sharp, participated in a National Judicial College civics program titled Reading and Robes with local Henry County students. Other news, the Ad Hoc Committee on Improving Community Access to Legal Resources, co-chaired by Justice Bethel and Judge McMurray, met yesterday with a full agenda, including the examination, the use of law libraries by the public. And Presiding Justice Namias recently gave the closing keynote at the Child Welfare Summit, our conference, and announced that nominations are again open for the 2021 Heinz Awards. Now, while we could not celebrate in person this year, we did observe Constitution Day on September 17th with the Twitter Town Hall. 18 Georgia judges participated, answering student questions via Twitter and enjoying some camaraderie via Zoom. This coming Tuesday is coming up on December 15th, will mark Bill of Rights Day with a Zoom panel discussion featuring several judges and students from around the state. In the new year, we will continue our efforts to help the Georgia Judicial Branch with community engagement and civics lessons, which is an important part of the Judicial Council's strategic plan. Turning to awards and honors, we are so happy to congratulate our fearless COVID-19 task force leader, Judge Sean LaGrua. We look forward to working with her and in her new role as justice. In other news, UGA has established the Judge Horace Johnson Jr. Lecture on Race, Law, and Policy in his honor. The Supreme Court was the recipient of a First Amendment Award for transparency in managing the COVID-19 crisis. And Chief Judge Russell McClellan was awarded the Ogden Doremus Kent Lawrence Award from the Council of State Court Judges. Congrats. The Georgia Office of Dispute Resolution received the Moving the Work Forward Award at the 26th Annual Georgia Commission on Family Violence Conference for its fabulous website that we helped to create. The Judicial Council's JRAC committee gave awards for clearance rate excellence, and the Chief Justice was recognized with a lovely outside ceremony for the official unveiling of the Harold D. Melton Student Center at Auburn University. I also want to congratulate all the court councils and ICJE for holding conferences virtually this year. That was a heavy pivot, and I've only heard good things. Thank you to AOC staffers LaShawn Murphy and Robert Aycock for their work to support the municipal and magistrate court training councils as they considered how to best serve their many members. In staff changes, as of November 1st, we were thrilled to welcome Ben Luke as our new Chief Technology Officer. I want to thank Sterling Perry again from our office, who stepped up when I asked to serve as the interim director of the IT division and provided a bridge for a very smooth transition. One of my key objectives as director is growing the next generation of court leaders. Accordingly, I'm both happy and sad to announce that Christopher Hancher is leaving the Judicial Council AOC today, is actually his last day, to become the Cobb County Superior Court Administrator. I'm delighted to announce that AOC Associate Director Stephanie Hines, who's on the call today, will be taking his place as Judicial Services Director. And she brings over 20 years of experience with the courts, the National Center for State Courts, and the AOC to that position. Congratulations, Stephanie. In general updates, the Access to Justice Committee had a very successful virtual records restriction clinic in Columbus, Georgia, coordinated with Judge McBride. And the committee recently received a Commission on Professionalism grant to continue this work. Well done, Tabitha, Latanya, and Justice Bethel, for your excellent work here. We've begun preparing for the new legislative session, which will likely be another interesting and challenging experience again this year. Judicial Council has several big initiatives, as you know, in the queue, and our team is already busy. I especially want to recognize our AOC Policy Council, Attorney Darren Enns, who you heard from earlier, for his incredible work this year in support of the petition for review legislation, working closely with Chief Judge McFadden and the subcommittee. Darren has helped to draft legislation to simplify, improve, and modernize the appellate process in several classes of courts. And now, for one of my favorite things to do, we welcome the newest members of the Judicial Branch family, our Judicial Branch babies. And we have a record number this year, all-time new record. Number 1, Justice Warren's little girl, Virginia. She was born October 1st. Number 2, Judge Gary Jackson's grandniece, Hannah. Number 3, Judge Wilkes' granddaughter. Number 4, District Court Administrator Steve Farrell's new grandbaby, Lily. Boy, is she happy or what? Jacqueline Booker with our HR department. This is her first grandson, Josiah. And number 6, Doug Ashworth's granddaughter, Libby. Now, we even had a kitten that was added to the team. So this is Michelle Barkley's kitten, Bear. And I think she got maybe scratched a little bit trying to get that baby bib on that kitten. As always, the AOC exists to serve you, the members of the Judicial Council and judges of the state of Georgia. During the holiday season, may you find joy, continued good health, and peace. Please stay well, wear your mask, and call on the AOC anytime we can support you. Thank you, Chief Judge.
Thank you, Cynthia. And as always, thank you for all the support you give to me personally, our court, and the judiciary statewide. We are grateful. As far as reports from the Supreme Court are concerned, you have our written materials. The 2 items that I would highlight for you, one has already been mentioned. You identified the loss of our good friend, Justice George Carley. He had a service yesterday. It was attended by mostly intimate friends and family, close family, and then it was broadcast through Zoom and Facebook Live. But it was a very fitting tribute to him despite the pandemic. And it was just really, it was an honor to be able to reflect upon his life and legacy as a man who we all came to know and love and respect dearly. So that was the other highlight. And then on the more upbeat side, you did mention Judge LaGrua. We congratulate her. We congratulate our court for the privilege of receiving her. And we extend our condolences to the Fulton County bench for the loss that they're about to incur. I was trying to see on this call whether she had begun packing. It doesn't look like she has, but we do want to congratulate her. We look forward to her joining us. Chief Judge McFadden, do you have anything to add for the Court of Appeals?
I do, Chief Justice. Thank you. We join you in the rest of the judiciary in the morning, Justice Carley. He was, of course, Judge, Chief Judge, and Presiding Judge before he was elevated to the Supreme Court, and he was the judge's judge. So we, in addition to mourning his passing, we also at the Court of Appeals have mourned the untimely death of our fiscal director of 21 years, Jan Range Kelly. She was extraordinarily hardworking and extraordinarily dedicated to our court and extraordinarily able. She delayed her retirement and ultimately, it turned out, gave it up in order to accommodate the consequences of the fiscal consequences of the pandemic. On a brighter note, we have hired a successor, Chris Walker, in whom we are quite confident and quite hopeful, continue to operate effectively, fully functionally over Zoom and remotely, and continue to express our admiration for the courts on the front lines who have the challenge of me dealing more directly with the public. That's it, Chief Justice. Thank you.
Thank you, Chief Judge McFadden. Judge Walt Davis, Business Court.
I want to echo the Chief Judge's comments on Jan Kelly. She caught the short straw on helping the Business Court get set up last year, and she just did a remarkable job, and we're going to miss her. A few thank yous and acknowledgements. AOC continues to do a wonderful job supporting us, but the new opportunities for both Christopher and Stephanie are well deserved. But you were going to be sorely missed over here. Same goes for Bob McAteer with the Supreme Court. He's done just an unbelievable job in helping build out the courtroom and get the technology working, so that we can start having in-person hearings when the time comes. And then finally, Judge Hodges for going out of his way to invite me down to Albany to speak and share thoughts on the business court. It was a very gracious gesture. I have a mask. I'll travel if anybody would like to have me in their backyard. Otherwise, happy holidays. Stay safe. That's my report.
Thank you, Judge Davis. Judge Amaro, Council Superior Court Judges.
Thank you, Chief. I'd like to congratulate Judge LaGrua on her appointment to the Supreme Court. She's been just a tremendous source of inspiration and really a hard worker on behalf of so many issues for the council over the years, and we greatly appreciate her work in the past and look forward to her perspective and work going forward on the Supreme Court. Next, I want to thank Justice Ellington for his assistance in managing our responses to the budget instructions that we've already discussed. It's delicate and important work, and we really appreciate him. Last, I want to say how grateful I am to be working with Superior Court judges statewide who are doing excellent work, calibrating their responses to shifting local conditions. This is a tough time. It's causing a lot of angst and concern, but folks are really doubling down and paying very close attention to the public health guidance. And so I'm just so appreciative for all of their work and feedback as we try to share our experiences and do our best to manage these difficult times. So that being said, we otherwise stand on our written report, and I want to say Merry Christmas to everyone.
Thank you, Judge Amaro. Judge Taylor, State Court Judges.
Thank you, Chief Justice. We will stand on our written report, but I will point out one thing. Well, I guess two. I guess I have to say it. I'll congratulate Judge LaGrua as well. Sean has been my friend and was my boss many, many years ago. And I'm excited for her new chapter. We will miss her in Fulton County, though. But as for the Council of State Court Judges, as I say, we'll generally stand on our report, but I will point out that as the year closes, we'll bid farewell to 8 of our state court colleagues who account for about 173 years of experience on the bench. And we wish them all the best in their future endeavors. And that is it for the State Court Council. I was so good that I think I made the Chief Justice freeze.
Well, oh, there you are. Okay.
He's back.
Now he's frozen again.
Presiding Justice, should we continue with the Council of Juvenile Court Judges?
I think that's an excellent idea.
Okay, thank you. We will stand on our written report. Congratulations, of course, to Judge LaGrua, and happy holidays, everyone.
Thank you. How about the Council of Probate Court Judges, Judge Walt?
We will primarily stand on our report. However, our Kevin Holder, who is our amazing executive director, is so efficient that he made our report perhaps a little bit before we actually completed our new judges training yesterday. I will say we had substantial compliance with masks, and we made yeoman's efforts to get everybody to distance and wear masks appropriately. We would also like to congratulate Judge LaGrua. Personally, I'm excited to get to work even closer closer with Mr. Hansford as he makes his way up here to Cobb County. And like the other courts, we will be saying goodbye to 29 of our retiring judges who have approximately 599 years of probate experience, which will be hard to duplicate and replicate, some of whom actually served as ordinaries. And hopefully we can continue to put our best foot forward and keep everybody safe. And we wish everybody happy holidays and happy new year.
Thank you, Judge Walk. And that is a massive loss of experience that hopefully the new folks can pick up and learn. Judge Hudson, Council Magistrate Court Judges.
We'll stand on our written report, and also we would like to congratulate Judge LaGrua as well. Thank you, Presiding Justice Anonymous.
Thank you, Judge. Judge Weaver, Council Municipal Court Judges.
Presiding Justice, it's with sadness that I report the loss of Judge Bernita Bender, Municipal Court of Valdosta, Georgia, a very young judge. She passed this week. Judge Bender was also a district rep for our council, as well as a member of my executive committee. She is an icon in her community in Valdosta, born in Moultrie. She'll be a great loss to her community and us. And we want the Judicial Council to keep her husband and 2 minor children in your thoughts and prayers. She had a 10-year-old and a 6-year-old. And with that, Presiding Justice, I stand by our written report.
Thank you, Judge Weaver, and we will keep her in our prayers and thoughts.
Presiding Justice Anonymous,
can
you hear me? Can you see me? Okay.
Now we can see and hear. You want to take back over? We are at the report of the State Bar of Georgia.
All right. Well, Elizabeth Fight, Ms. Fight.
Good afternoon or good morning, everyone. Still, as you can see, for those eagle-eyed folks, I am in the car, but I am pulled over. I am stopped. I even took off my seatbelt as I got out and walked around. Just to report briefly, we'd like to echo all the condolences expressed for Justice Carly. Many of you may not know, Justice Carly presided over the young lawyers swearing in for years. And so there is a generation of younger lawyers that are now not so young who were sworn in as YLD officers with Justice Carly presiding. So we will miss him and we feel his loss as well. We also like to give our congratulations to Judge LaGrua. I've had the privilege of working with her this summer over the COVID task force, and we are really happy for that. As it relates to the business of the bar, our mid-year meeting is scheduled to start January the 9th. It was to be a hybrid meeting. We have shifted that to be a fully virtual meeting again. And so the meeting will be really Saturday morning, and Friday night we will have some virtual social events to participate in. The Bar's Advisory Committee on Legislation met December the 1st to begin finalizing our 2021 legislative agenda. The committee voted to support 2 judicial council proposals, as well as the Uniform Mediation Act and support for remote online notary legislation. Those proposals will be submitted to the Board of Governors, who will vote at the mid-year meeting on that. And then finally, as it relates, we've had some to staffing changes at the bar. Our new executive director, Damon Elmore, will start in January, and we are excited to have him. And we also give our best to Jeff Davis in his retirement from the bar. And Sarah Cool, who was a communications director, has now been promoted to our chief operating officer, and she has taken over. For those of you who knew, Sharon Bryant retired in October. So with that, we always appreciate the opportunity to be here and have a seat at the table. And I wish everyone here a happy, happy holiday.
Thank you, Ms. Fight, and drive safe. Okay, Council of Accountability Court Judges, Ms. Taylor Jones.
Hi, good morning. CACJ is primarily going to stand on our written report, but I did want to highlight that at our virtual conference held in September, that we recognize an inaugural set of model mental health courts as well as model DUI courts. And a list of those courts are contained within our written report. And I also want to point out that during our virtual conference, Chief Judge Kathy Gosselin was recognized as the recipient of the inaugural Judge Stephen S. Goss Award. This award was created to honor the life and legacy of him as a nationally recognized expert on mental health. And CACJ again thanks you Chief Justice Melton for presenting that award to Chief Judge Gosselin. And
Well, I'll tell you, that was my honor to do so. Thank you for including me. Ms. Tracy Johnson with the Commission on Dispute Resolution.
Thank you, Mr. Chief Justice. We do have a written report, but I just wanted to highlight a couple of items. As Cynthia mentioned, we are very honored to be this year's recipient of the Georgia Commission on Family Violence Moving the Work Forward Award. We are appreciative to the Georgia Commission on Family Violence for their collaborative partnership. The rules for mediation in cases involving issues of domestic violence go into effect this January. And last week, we wrapped up our training for the year, having trained over 800 neutrals and all court program staff in the 42 trainings hosted this year, most of them done virtually. We want to thank Ms. Allison Lerner with the JCAOC for her assistance in drafting these rules and also her role in the staff training. I do want to give a shout out to Mr. Sterling and Ms. Juliana Tyler with the JCAOC IT team. They developed and implemented the online screening tool that we are using. This tool is now live, available to all programs, and the purpose is to help programs collect screening responses from litigants in an effective and efficient manner. These new rules, along with the online screening tool, continue to advance Georgia's status as a national leader in dispute resolution. The last thing I want to mention is our 27th annual ADR Institute Neutrals Conference. It is virtual this year. We launched it last week. We have already sold 256 tickets to the event, and we expect the overall attendance to exceed that in previous years. So thank you and happy holidays, everyone.
Thank you. Mr. Holloman, are you here with the Council of Superior Court Clerks? How about Ms. Robinson? Okay, we'll move on to the Commission on Professionalism. Ms. Greer, are you there?
Hi, yes, I'm sorry, can you hear me?
Yes.
Hello? Okay.
Yes, we can hear you.
Good morning. First of all, I want to offer my condolences also for the loss of Chief Justice Carley, as well as the other judges who've been mentioned on the phone this morning. I want to extend my congratulations to Judge LaGrua on her appointment to the Supreme Court of Georgia, and to thank Judge LaGrua and Judge McClellan for their help on the Commission's upcoming and final CLE for 2020. This will be our 7th one this year. It will take place on December 17th. I want to thank the judges who are participating, including Judge McClellan, Judge Leonard, Judge Alvin Wong, Judge Shondina Cruz-Moores, Judge Dillard, and of course, Chief Justice Melton. You've been great in participating in so many of them. Also joining us will be Tracy Johnson. Despite the 800 people she's just trained, she will also be joining us to talk about some ADR issues, and I want to thank her as well and thank the AOC for your support of this event as well. The Commission has some other information in its written report, but I hope to see some of you virtually on December 17th. Thank you.
Thank you, Ms. Greer. Council of Court Administrators, Ms. Rooks.
Thank you, Mr. Chief Justice. We primarily stand on our written report with a few brief comments. In lieu of our fall conference, GCCA hosted in October a one-day virtual training and business meeting. The virtual training was very well attended and focused primarily on COVID-related challenges, both from a judicial and court administration perspective. During our business meeting, our council body elected officers sworn in by Chief Judge Jeffrey Bagley. A list of our new officers can be found on our website. GCCA continues to expand its platform of providing educational services through our quarterly podcast in recess. Our next podcast is entitled, What's the Verdict? Restarting Jury Trials Post-COVID, and this will be released in January. I invite everyone to listen to our podcast. It will be released, as I said, in January, and also listen to some of our past podcasts that explore interesting court-related issues. That concludes our comments. Happy holidays to everyone. Thank you.
Thank you. Mr. Ashworth, are you there with the ICJE?
Yes, sir, Chief Justice, and may it please the courts, I'm participating by phone. Our written report contains the master calendar of events for calendar year 2021 as approved by our Board of Trustees and our fiscal year 21 financial report to date. Thank you, sir.
Thank you. Mr. Boring, do you want to respond to Mr. Amati?
Yes, Chief Justice, thank you. I do want to congratulate everyone on this Zoom for having made it through the entirety of it, even after likely many people were wanting to go to sleep during Mr. Amati's presentation. So congratulations, everyone. I do want to say congratulations to Justice LaGrua as well. She's going to be a great addition to the bench. Also, kind of personally, I want to thank everybody on the council at AOC for helping me survive my first year on this job. As many of you have heard me say before, if I'd really had this explained to me before I took the job, I don't know if I'd be sitting here. But in all jest, I really do appreciate all the guidance I've had from everyone. And, you know, this wasn't exactly the year we wanted, but it's the year we've been given. So I am proud of not only the Judicial Council and the AOC, but the judiciary as a whole as to how everybody's come together and handled some really difficult times in some very creative and, novel ways. So with that, I appreciate it, and everybody have a good holiday.
Thank you. All right, for old business, I don't have any old business, but I do want to recognize a couple of our outgoing members. We have Judge Van Pelt on the meeting call today, and this will be his last meeting, and it's a well-deserved last meeting. And we want to take a moment to recognize him and thank him for his level of service and also his length of service. He's been the 7th Judicial Administrative District Representative for 2.5 years, which I believe is a record. And he's agreed to even extend to get to that point because of the press of business. And so he just stepped up whenever needed. So not only did he attend every judicial meeting except for one emergency meeting, but we'll say that that's every one. He stayed awake and he took notes, and he sent around summaries of every meeting, no matter how brief. Now it says no matter how brief, but that also includes no matter how long. And so we are grateful for his level of service and his length of service. And Judge Van Pelt, we want to thank you for all you've done. We wish you well. I know that we will probably see you again in some form or fashion because that's how you are. But we are grateful for all you've done to serve our judiciary and to make our state better. So thank you very much, Judge. Lastly, Christopher Hancher. You heard a good bit so far about what he's going to do next. Cobb County has made a very wise decision, as Judge Emerson pointed out, and Judge Emerson is not an easy man to please. He has a high standard, and I think we all can say that Christopher Hanford has exceeded every one of our expectations. He's met every need that we've had. We've gotten to know him, we've gotten to trust in him, and we will miss him greatly. But we are in a better place because of what he's been able to provide for us. We have a resolution that I want to read, if you will indulge me, in honor of Mr. Hansard. And it says as follows: a resolution commending the service of Mr. Christopher Hansard as Director of Judicial Services Division of the Judicial Council, Administrative Office of the Courts, and for other purposes. Whereas Mr. Christopher Hansard has distinguished himself throughout his career by his devotion to duty over many years of service to the judiciary, and whereas Mr. Christopher Hansard began his career with the Judicial Council, Administrative Office of the Court in 2010 as a research and statistical analyst, and whereas his continued record of excellence and leadership resulted in a series of promotions until he was named Director of Judicial Services Division in December 2015. And whereas under his leadership, the Judicial Services Division and its constituent offices consistently demonstrated the highest levels of professionalism as it provided quality service to clients throughout the judiciary. And whereas he has faithfully served as staff to the Standing Committee on Judicial Workload Assessment and served as a trusted advisor to its chair and members and a partner to its many stakeholders. And whereas during his tenure, annual caseload reporting from Georgia's courts has consistently exceeded 95%. And whereas such actions have brought positive recognition to the Administrative Office of the courts, including a 2014 award in reporting excellence by the Court Statistics Project of the National Center of State Courts. And whereas Mr. Christopher Hancher additionally served in leadership roles in various organizations such as the Georgia Council of Court Administrators and holds the distinction as a class of 2019 fellow of the National Center of State Courts Institute of Court Management. And whereas Mr. Christopher Hancher has also faithfully served his family and his church community. Now, therefore, be it resolved that Mr. Christopher Hancher is hereby recognized by the Supreme Court of Georgia and the Judicial Council of Georgia and his colleagues of the Judicial Council Administrative Office of the Courts for distinguished service in the aforementioned capacities. And be it further resolved that the Judicial Council forward this resolution in an appropriate format to Mr. Christopher Hancher as a token of the council's esteem for his outstanding leadership, fellowship, good humor, and friendship, as this is bestowed upon him by his colleagues and the citizens of the state of Georgia, presented this 11th day of December 2020. Signed by me as Chief Justice. Mr. Christopher Hancher, we thank you. We wish you all the best, and we know you will continue to serve in meaningful ways. Thank you so much. And Ms. Clanton, do you have the presentation? Do you have what we're handing him?
I got it, Chief. It's big. It's ready to go.
Okay. All right. So to conclude, we have our next scheduled meeting in February on the 12th. That will be by Zoom. Stay put. We'll try to let you know when we'll have our next emergency meeting. A lot of that will depend on what the numbers look like. If we can push it off to the following week, we will. But if we need to gather quickly, we'll do that as well. That's all I have for you guys. This is our last meeting before Christmas. I wish you all a Merry Christmas. I wish you all a Happy Hanukkah. I wish you all a happy holiday season. And above all else, enjoy time with your family and stay safe, and look forward to seeing you all again. Thank you very much.
Thank you. Be safe. See you next year.